How many members do you guys have?
There we go. All right, so we are ready to get started over here. First, want to just start by thanking everybody who's made the time to come and join us today on Memorial Day weekend. We know that many of you guys probably have plans to spend time with friends and family, and yet you still made the time to come out, educate yourselves, and network with the rest of the group. I also noticed that there are a couple new faces joining us this month, so if you are newer to our meetup, welcome. This is an incredible group of individuals, and we hope to keep continuing to show up so that all of us can get to know you a little bit better and help you grow. Today, we have a very special guest who's going to be joining us and giving us some information that many of you may find very useful given the current state of the market and the unknowns related to the lift in the COVID-19 eviction moratoriums. We have Bibek Das. He is the founder and managing partner of Das Law with a focus on commercial and residential real estate transactions and litigation. He has spent the last 20 years educating and protecting Chicagoland investors and landlords. And last year, Bibek was featured on the Straight Up Chicago Investor podcast number 17, where he discussed the legal pitfalls to avoid as a Chicagoland investor. The focus of this month's meetup is on the processes related to the evictions, the sales of investment properties during this time, and the pertinent issues that tie the two together. So Bibek, thank you again for coming. We're all happy to have you here, and I'll go ahead and pass the mic over to you.
No worries. Thank you so much. And thanks for everybody's participation. I know it's Memorial Day weekend, so I appreciate it with all the interest and all the craziness that's still going on in the world of COVID-19, which we are hopefully getting to the end of. But that being said, I know all of these investors I get a lot of questions about what's going on with evictions pretty much daily. So hopefully what I present here today will at least give some guidance. And today, just so everybody has it, is actually May 30th, 2021, because some of these laws and enforcement issues change by the day. So if people do watch this in the future, they're aware of when this was presented, so you have it. Just as an introduction, all evictions are currently on hold. That's not just in Illinois, but countrywide, with a few exceptions, which we'll review a little bit later. The items that really actually govern the current eviction status and the moratoriums are both. Here you've got federal, Illinois state law, and City of Chicago ordinances that govern how the moratorium is being handled, how evictions will be handled moving forward, as well as currently in the obligations of owners and landlords with respect to that. So I'll be covering those topics. And to really begin with is we start with the federal moratorium. Currently, there is a federal moratorium that's set forth by the CDC. This was issued back in September of 2020. And really the basis of this is that the CDC felt that there was a requirement to protect individuals from spreading COVID-19 throughout, and the issues that could come about if there are evictions, enforcing evictions, displacements of tenants, whether tenants would have to go to shelters, et cetera. So this was put into place by the federal government. It is still in effect. I'm sure many have heard that there have been lawsuits that have been filed in various states. Actually, there was a state in Virginia that the lawsuit went up, and the courts actually stated the CDC didn't have authority to go ahead and enforce this moratorium. However, that is actually currently up on appeal. So as it stands, the CDC order, which President Biden has extended, is still in effect until June 30th of 2021. This is still pending what occurs on appeal. It could be overturned or it could be upheld. And so, people will have to keep track of how that goes. Again, I said it's May 30th, so that could change in next week, or it could change a month from now. It could be extended as the vaccinations go on, and it's determined whether or not evictions can move on. And then the safety and health issues that are a concern of the CDC is really going to be enforced, and if it's required to be enforced. People may be aware of the restrictions of evictions under the CARES Act, which was provided a moratorium on evictions for properties that were secured under mortgages backed by the federal government. So that would be properties that you would have, they're held by Freddie Mac or Fannie Mae, or if even an owner actually got a PPP loan, a lot of those type of federal backings would be basis to enforce CARES Act moratorium. This overrides that. So that actually only applies to those type of federally backed properties, but doesn't apply to properties. Let's say if an individual owns a property free and clear, has a 2-unit building and just tenants in place, but owns it in cash, that the CARES Act apply, but the CDC Act, on the other hand, does. And that extends to all residential properties, regardless of whether they're secured by federally backed mortgages, and that are occupied tenants who meet certain income thresholds. They've applied for government assistance, have lost income due to the pandemic, and would be rendered homeless if evicted. So to talk about what will be governed under the CDC federal moratorium, we'll talk about what is called covered persons, okay? A covered person is one who meets all of the following metrics. Again, this is under the federal, so I'm going to be talking about state and city guidelines as well. So under one, if it's an individual that either one expects to earn no more than $99,000 in annual income in the calendar year of 2020, or no more than $198,000 to filing a joint tax return, or alternative was not required to report any income in 2019 under the IRS, or received economic impact payments pursuant to Section 2001 of the CARES Act. That's step one, that they would be considered a covered person. Secondarily, if the covered person would apply if they're unable to make full rent or housing payments due to a COVID-19 related hardship. That would be including substantial loss of income, loss of compensable hours or work or wages, or an increase in out-of-pocket expenses directly related to COVID-19 pandemic. Now, these can vary. It's kind of broad and a little bit ambiguous, but most tenants can probably claim one or all of these due to their work situation as well as their home situation. The next is that the individual or the tenant is using their best efforts to make timely partial payments that are as close to full payment as the individual circumstances may permit, taking into account other non-discretionary expenses. So again, this is a little bit open-ended and broad, but as long as the tenant's able to show some kind of good faith efforts, they were trying to make payments, but they're still behind and they're lagging, they would still fall under the covered person's requirement. And finally, the eviction would possibly render the individual homeless. So this is another issue that you come up with where, which is the main concern of the CDC, is that the individual will be rendered homeless. You're going to have shelters fill up with tenants or displaced tenants, and that causes a problem in various ways and could potentially lead to the spread of COVID-19. So that is really the main reason why the CDC was basis in which they wanted to have this requirement in place. In order to ensure that the landlords are complying and working with the tenants and there's no violation under the CDC requirements, landlords have to give tenant an opportunity to demonstrate that they meet the 4-part test. They're required to provide a declaration form to the resident at least 5 days prior to the notice of termination, i.e. in the cases of non-payment, you'd have a 5-day notice, which is customary especially in Illinois, Cook County location and City of Chicago location. So I'll ask to share the CDC form, which I think I just forwarded. I don't know if you're able to screen share that form. So this form should be given to the tenant at least 5 days before. You can find this form on the CDC website. And it does provide all the checklists, which they can sign and submit to the landlord. Again, and I'm going to say this in the future as well, these are documents that you should have in place before filing an eviction, because if you don't have these documents, it can give good reason for any eviction that you file, even after the moratorium's up, that could give tenants reason in which to get the eviction lawsuit thrown out. So this is a form that you can get from the CDC website. I'm sure Windy City REI can also share these. They do have these documents as well. So this is the requirements under the CDC before you can even proceed with an eviction. But that being said, I'm going to move on to what's the state of Illinois, because the state of Illinois also has its own requirements that fall lockstep with the federal. The Illinois state eviction prohibits the filing of residential eviction actions and enforcement of residential eviction actions as of, which is supposed to expire by the end of today. Now it's extended every month by Governor Pritzker. You know, what I'm telling you today could very well change by tomorrow if he doesn't extend, but it is anticipated that he will extend it. He has been on record stating that he's going to extend it, but with the intention of phasing it out by August of 2021. Now, nobody's quite clear what he means by phasing it out, whether it's just going to be a complete end of the eviction moratorium, whether they're going to do it in parts. But as of right now, the eviction moratorium is in place as of today. It will likely be extended another 30 days, and I anticipate it'll be extended through July, and then we'll see what happens and come August. Always remember that federal requirements will trump over the state. That's also going to be in place, but you're going to have your state requirements. And then you're going to also have City of Chicago requirements, which we'll go over, that'll work in lockstep with the Illinois moratorium, okay? Again, please keep an eye out as to what the state is doing. You can find it pretty easily by just doing even a Google web search, just the current status of the state moratorium. Again, we anticipate August, but unclear how that's going to roll out. In June of 2020, the city of Chicago also passed an ordinance to protect city of Chicago tenants. So this has an additional layer of protection for under the moratorium. So you've got both, we've already talked about the federal, you've got the Illinois state, and now you got city of Chicago. Under this moratorium or ordinance, you're gonna have a couple of requirements, and again, a little bit open-ended as to what can be determined as good faith. And you're going to hear the term good faith and what entails good faith. Under the ordinance, landlords are to make a good faith effort to resolve any non-payment disputes with tenants. This is such as establishing communications and allowing a 7-day grace period before proceeding with eviction cases. Something I failed to mention in the previous, under Illinois state, under the Illinois ordinances and the requirements for the moratorium, the filing of an eviction is essentially prohibited. It's going to get tossed. So even if you go ahead and you get the notices, the way the statute reads, it will get dismissed by the courts. And there's a form that you have to fill out that with the filing of any eviction that the judges are reviewing before they go ahead and even allow an eviction to proceed during the moratorium time. Because there are exceptions to the moratorium, and we'll talk about those. Now back to the city of Chicago moratorium. The ordinance applies to all dwellings within the city, okay? So under that, you have an extended grace period, kind of referred to as a cooling off period, that provides an additional week following the delivery of the 5-day notice that Chicago landlords serve to the tenants to initiate the eviction process, okay? In order to benefit from the 7-day extension, tenants must serve the landlords with a tenant notice in response to the receipt of the standard 5-day notice. I'm going to ask to share also a screen share page 2, which is the eviction protection ordinance. As we pull that up on the screen here, this document, it will be available again. You can find it online as well. I'm sure Windy City REI will have it available. This document needs to be provided along with your 5-day notice. If it's not, your case is going to get dismissed. This provides the tenant the knowledge that as to what their rights are under the City of Chicago ordinance. In order, again, to benefit from this and to get that additional 7-day extension, which gives you essentially a 12-day period from the time that you give the 5-day notice along with this notice, the tenant can give a notice of their hardship and that they have a COVID-19 impact. And during that 12-day period, the landlord must contact the tenant and try to work out a plan to avoid an eviction. Okay. These are steps that you need to take. And I say this now in anticipation when the eviction moratoriums do get lifted. You're going to have a scenario where these judges are going to get these cases, and there are lots and lots that are piled up and waiting. And I anticipate most of the judges are going to look at this and ask, hey, did you give this know your rights document along with your 5-day notice? And I anticipate most of the courts are going to try to keep too many evictions from proceeding, and will find any which loophole to prevent too many evictions, where the sheriff's going to be overwhelmed, possibly shelters will be overwhelmed. There's going to be a lot of displacement all at once with all these evictions that are going to come. So strict adherence to the rules is the best way to go and the best path forward. Moving on to the next page, we can go back to this. Yeah. And a plan to avoid eviction, in terms of when you have that good faith cooling off period in which you're supposed to contact the tenant, you can either contact the tenant to make a repayment plan, you can engage if there's no chance of you getting to a resolution, to engage in a mediation or an arbitration. You can alternatively come, and I say by written agreement, allow them to use their security deposit if one is being held to cover any missed rent. You can also have an agreement, essentially what we call a cash for keys scenario, where you can have an agreement the tenant will agree to move out without having an eviction judgment rendered against them. There are other agreements the landlord can try to work out with the tenant. I always say get all of these agreements placed in writing in some form or another, because sometimes you run into trouble later if you don't have it in written form. The ordinance also requires that a repayment plan must give the tenant at least 2 months to repay each month of missed rent. So you can extend that time, but it can't be shorter than that. So you should have that in place and be aware of that, or else then it'll not be considered a good faith agreement. So if it does come time for an eviction, you're trying to enforce it, they're going to find out that the agreement itself wasn't enforceable. Again, the ordinance does not require that the landlord and tenant reach an agreement, but a good faith effort to do so. What constitutes good faith? That's really subjective, and it's going to be up to the court to decide if it does get to eviction. Sometimes they'll say, hey, you know, a tenant reached out many times by email and the landlord didn't respond. Is that good faith? I don't think that's good faith. Probably a court would find that not to be in good faith. Again, if a landlord doesn't use good faith, or the tenant's able to prove that they didn't use any good faith, and files the eviction and tries to move forward with it, the court will dismiss that eviction. So it's really important to document that you're trying to work it out. You couldn't make an agreement, you couldn't reach one, and hopefully you can. That's unfortunately a situation a lot of owners are having to deal with. On the next page, we'll share screen 3 also, which is a tenant notice. This is just a sample tenant notice that most tenants can probably find on their own as well, that they give to the landlord, giving their name, their information, that they can't come into an agreement, and that they have to provide to the landlord. So there are some obligations from the tenant, and it's not just landlord based, but if the landlord is going to go forward with trying to enforce an eviction, that these are the steps that they're going to need to take. Now, I mentioned that we'll talk about exceptions to the eviction moratorium, which is the next page. I'm pulling that up. There are exceptions, and I'm sure many of you heard that there are scenarios where you've heard say, hey, somebody got a tenant out, got an eviction, but hey, there's been a moratorium. How did that happen? Well, there is a safety reason. Landlords may file an eviction proceeding if a tenant poses a direct threat to the health and safety of other tenants, an immediate and severe risk to the property, or a violation of any applicable building code, health ordinance, or similar regulation. You know, the examples, this can vary, but essentially these would be considered, you know, what you'd consider on a 10-day notice of default under a lease, where, you know, sometimes there's There might be tenants who are potentially a threat to a neighboring tenant, is threatening them maybe with a gun or something like that, and you have evidence of that. This is a reason why you can go ahead and evict. I know people have tried, or landlords have tried to circumvent, try to get evictions in, saying that something was a severe risk to property, maybe smoking a cigarette. It's going to be subjective. The court's going to determine that. The court's going to, each judge is going to make a determination whether that is, and whether they'll enforce the eviction under that ground. So again, it's a little bit ambiguous and subjective, but I think most landlords know under a lease, when you have a severe threat, you know when to evict and issue a 10-day. All these moratoriums do not apply to commercial property, so it's only for residential. Commercial property evictions are applicable at this time, so they can move forward. The next document that we'll share, I think it's share number 4, is what we call the certificate of compliance. Now, if you have an attorney or you're doing it yourself, it is imperative that you attach this document along with your standard evictions complaint and summons. This is a certification by the landlord and the plaintiff of compliance and why this eviction can move forward. So you can see under section 2A, one of the more following applies. The defendant in this scenario is a direct threat, so therefore the eviction should move forward. The defendant is an immediate threat to the risk and a risk to the property. I don't know, maybe they're a pyromaniac and they're trying to set the property on fire. That is a good reason to get them out. Alternatively, the property at issue, as we said, is non-residential. So if it's a commercial property, you can move forward. And then alternatively, prior to commencing the action, the defendant owed rent, you serve them the form declarations that we talked about, and you did not receive a qualifying declaration from any of the tenants that they don't qualify as a covered person. And then you receive that declaration in good faith, do not believe it's a valid declaration. These are things that you're going to have to prove up in court, but I will say this form, when it's submitted, is something that the judges will look at. And if this form is not attached, they'll toss the eviction right off the bat before you even get a date. But if it is checked off, they're going to make sure, and they're going to pass this through to the handling judge. And then you'll get your eviction date, and you're going to get your hearing date. But all of these things will need to be proved up. All right. Now, kind of moving on to the unknowns. So how are courts going to treat evictions when they start? And this, when I say eviction when they start, they are going on right now, but I'm talking about non-payment based evictions. What I mentioned before, we don't know. But one thing we do know is that there's going to be a lot, and they're going to be filed. There are going to be landlords everywhere who have already filed them or just waiting for them to pass through to get to the judge for hearing. I anticipate most judges are going to go by strict adherence to the rules, that all the forms have been followed, all the proper notices have been given, your 5-day notices are done correctly. I think they're going to take every which opportunity in which to dismiss an eviction. They'll take it because for public policy reasons, they don't want to have a gazillion people roaming being evicted. You've got enforcement issues with the sheriff. That's another whole unknown, how the sheriff's going to handle this. You know, Tom Dart has his concerns. He's a very tends to be tenant friendly to some extent, especially in Chicago and Cook County. So a lot of the owners may be aware of that and know in the dealings with the sheriff's office, they've only got so many employees to go out and handle evictions. And if you've got a slew of them, you know, I think there's going to be, and this is really more of a guess, but I can read the tea leaves that they're going to do everything to try to keep these evictions in check. And we're going to see how Governor Pritzker lays out his slow removal of the moratorium and how he will do that. Finally, I'm going to touch on this because this is something that comes up quite a bit, which is impacts on investment property purchase and sale. So I do a lot of transactions of investment properties. And what happens a lot of times is, you're selling to a buyer, you're going to be assigning leases, they want rent rolls, they want tenant Estoppel letters, etc. And lo and behold, they see, oh, there's a tenant here that has not been evicted, has not paid since March of 2020. What is going on in that situation? And I've seen the scenario pop up many a times where just, I don't know if the owner was thinking, hey, I could just pass through, everybody knows the problem, etc. Get ahead of it, all right? Figure something out with that tenant, whether that's cash for keys. Make sure you come up with the cash for keys. Maybe you can get the tenant out in a way before the closing, and they'll leave and they'll vacate. And you can give the tenancy, free of tenancy of that defaulted tenant to the incoming buyer. I'm a big believer of full disclosure. Hiding it is not the best idea. So, you know, when you're listing the property, the agent should know, they should make them aware, hey, you know, we have a tenant. Maybe it's a good tenant. Maybe it's a good tenant that just happened to lose their job. They worked in the restaurant industry. They had difficulty, you know, making wages, but restaurants open up, and you might be able to convince the new buyer, hey, take this tenant on. They're gonna make their payments. You as the owner may have to eat the last 12 months maybe of non-payment and pass it on free and clear to the new owner. The other thing I was mentioning, accurate rent rolls and documentation, Estoppel letters. I've had one scenario where I was on the purchase side where there is a lawsuit now pending where the landlord fraudulently created Estoppel letters and signed, and the tenants really didn't sign them. They were back on rent. So you don't want to run into that problem because the cost of that is going to be significant, and the liability and the issues that come with that is not worth it. So the juice ain't worth the squeeze if you're thinking of trying to kind of shovel that under the rug. Now, buyers are aware of this, these scenarios, and there are various things that you can do during the transaction process. Sometimes I've seen where there'll be an escrow holdback where the landlord will agree, hey, I'll hold, or the owner may agree, hey, I'll hold back X amount of dollars. We'll hold it in escrow with seller's attorney, buyer's attorney, or with the title company. And when the eviction moratorium comes up, I'll take on the responsibility of trying to get the eviction done, or I'll pass it on to the buyer and they can tap into that escrow and it can be released. That way you get the transaction done, but that open-ended tenancy issue is hopefully resolved. Alternatively, you can offer closing credits. Say, hey, look, we understand this tenant is in there, but we need to close on the property. You can offer closing credits of a certain sum of money that might be worth it. And certain buyers are smart, and look, they look at this investment property, they're going to look at it and say, hey, you know, this thing's going to get resolved anyway, and I'm going to hold on to this property for the next 20 years, and it's worth it. And, you know, I'll take closing credit and take on the headache of the tenancy. So those are the things that we come across, that we've been coming across on transactions. You know, this is just kind of an overview of what's going on currently. And I'll open the floor to questions. I think we might have some. So
I have a quick question. So since the the eviction has not been renewed yet, can people evict next few days, or how are they going to do that?
Well, I mean, it's going to get, Pritzker usually waits till the last possible second. If you have, I'm assuming if you haven't issued your 5-day, you're not going to be able to do the eviction.
Well, yeah, I was just wondering for, you know, I'm sure people want to know that answer. Like,
yeah.
So today, so.
Yeah. So, I mean, again, button up your paperwork. You can still issue your 5 days. Okay. What you cannot do is start the eviction, file the eviction. All right. So get your paperwork in place, get all those documents. You can do that now. There's nothing that prevents you under the moratorium from giving the notices. What it's saying is that you cannot go ahead and start the eviction and file it. Okay. So if you've got all your paperwork in place right now, you're good to go. And then once that moratorium is lifted, whether it's tomorrow or the day after, then you can give it to your attorney or go ahead and go in the process. But again, remember, if you don't have those documents in place in the first place, you're going to get it to the judge and it's going to get tossed, and you just wasted a lot of time and money.
Vivek, I also kind of wanted to just clarify too, because you had mentioned that 5-day declaration, but there's also that 7-day grace period, right? So
Correct.
in reality, it's really 12 days giving the tenant an opportunity, right?
If the tenant responds. So the tenant's supposed to give you a notice. And so that's that burden that I was saying, that not all of it is on the landlord. I mean, most of it is, but everybody knows tenants can say, oh no, I did give them notice, I called them, or I sent an email, blah, blah, blah. So if you really want to be on the safe side, give them the 12 days before you go and file the eviction. I recommend that. That way there's nothing that comes up during the eviction where a tenant comes floating in and says, hey, I talked to him, oh, I sent him this email, or I did give this to him, brings this paper, which obviously the landlord probably never got. So if you want to play safe, it's what's that extra 7 days to you at the end of the day. What's going to be worse is if that scenario pops its head and you've just wasted your time on this eviction and have to go back to ground, start phase 1 and do it all over again. And you've wasted money and you've wasted time. So Chris, you're right. Like, yeah, it's technically 5 days, but I would wait to 12. I think somebody had a question on the
Pat Gage asked, when you do a cash for keys, what documents do the landlord have to get signed to be protected?
We usually, for my clients, I draft a cash for keys agreement. I've seen quite a few scenarios where people take it upon themselves and don't get anything in writing, don't get waivers. There is no actual specific form. You can kind of Google forms and look for cash for keys type agreements on Google and whatnot. And I warn people, be careful what you pay for and sign for, probably best to confer with an attorney if you can. Some people are smart enough to do it and figure it out on their own, but you want to get it fully documented. You want to ensure that they're out. And the other thing is, don't pay them until they're out, until you get possession. I've had that scenario happen where someone's like, hey, this guy promised me that he was going to be out. I gave him money and he's now not responding to me. Well, you're pretty screwed. You don't have a written agreement. You gave him the money. I don't know how you're going to claw that back. He's just sitting on it. Yeah, you can sue him. There's a lot of various scenarios that you can do, but you're pretty much SOL. So absolutely, I tell all my clients, your agreements are worth the piece of paper they're written on. So if you have nothing it's written on, it's worth nothing. So me as an attorney, the most difficult things that I ever have to deal with is oral agreements. I mean, everybody's just going to say what they're going to say, and you don't know how that's going to play out in eviction. So I always say document. You cannot get burned when you get it documented, and you'll know what your issues are beforehand. So cash for keys, we draft them. You can feel free to reach out. There are a lot of protection you should have in place. You want to ensure that the tenant's not going to destroy the property. They're not going to do, I've seen scenarios where they've pulled out the copper pipes right before they leave. And, you're like, you have to deal with that scenario. And if you go in and as you're taking possession, you see it, then you don't have to give them money and then you got something to enforce. One other thing that I think I forgot to mention, although evictions themselves are now prohibited, what I have talked to some clients to do is just to get the ball moving is, don't forget, it is ultimately a lease as a contract. You can still file a breach of contract claim for the money. They haven't paid, you can file something in small claims court strictly as a monetary claim. That doesn't constitute an eviction, it's an alternative. Now, these tenants are savvy. They know that, hey, I'm going to show up. It doesn't matter. You get a monetary judgment through the eviction anyway, and whatever, you've got a monetary judgment. And sometimes they're that defendant that just you can't beat because they might not have the assets, but sometimes just even the threat of it might get them moving. Something I'll say, now that Pritzker said and gave kind of a line in the sand, whether he backtracks on it, now know August 2021, if the tenant Googles it right now, they'll be able to pull up Pritzker's going to stop the moratorium August 2021. You guys are now June, and you were having these problem tenants. There's no reason why you can't go to them and be like, by the way, in 2 months, I'm going to file your eviction. here it is. So like, what do you want to do? You've been waiting since March. You haven't done anything. You've got something to hold on to. So you've got an argument here. It's a difficult position for owners, but you know, I think the light at the end of the tunnel is coming. You can see it.
What are the typical amounts of cash for keys, like in response to the rent? Can you give us an idea?
So it depends case by case basis. It depends on how savvy your tenant. Some of them will take $1,000 and be like, I'm out. And I'd be like, take it, run. But I've seen tenants who, there was one scenario where a client was trying to sell a property, and they had a coach house, and the tenant was back there, and they actually bought the property, and they were working out the cash for keys. He didn't even live there. He had all his stuff there, would come in and out. The police, they tried to get him for trespass. The police are like, no, this is an eviction issue. We're not dealing with it. Every time they go to him, it'd go from 10,000 to 15 up to 25. And it just became, I mean, I have no answer. You're going to have to, hopefully you have a good relationship with the tenant. Hopefully, you know, that amount of money, you know, start low and see where they go.
So Bibek, Jim Biggs, the wonderful founder of the GOB, he has a question. Are courts enforcing notice to vacate at lease termination, for example, like month-to-month leases that are ending?
They're not going to do no. They're not doing any evictions on those either, because they're considered essentially non-payments.
No. So if a month-to-month lease is ending, so if the landlord says we're ending your lease, we're not continuing month-to-month, are they enforcing the notice to vacate, or
they're
not
not doing that right now? They're considering not non-payment reasons. Again, this is a safety reason. There are a lot of month-to-months. I've had this question before. Really, the only evictions they're allowing are gonna be safety issues based. Okay, so you can try the month-to-month. I'm not seeing it get passed. It might be by sheer luck if you get maybe a judge. So, again, it can sometimes change from courtroom to courtroom. I have specific judges that I know when I'm in front, I'm like, this is going to be bad. And there's some that I'm like, yeah, I just give the 5-year notice. They may not even ask me for the city of Chicago documentation. And we're like, yeah, okay, and rubber stamp it. So you're kind of weighing that risk, but I don't consider month-to-month you know, because it would be essentially a non-payment issue. And if you've accepted the rent, there's no reason to vacate. So you've got to not accept the rent. That's the other thing that people, once you accept that month-to-month, it extends another month, by the way. So don't forget that.
Another question from Jim. Do we have a source of actual eviction numbers? Are the judges being very tenant friendly, even for legitimate evictions?
I don't have any numbers. You know, there are some going through. I don't know how many. I don't know the exact numbers. They're not really releasing that type of information. Evictions are going through, but what I was saying before, it's case by case. It depends on which judge you're getting. Some judges will find the most basic thing that, you know, kind of bores, whether that's a safety violation. You know, they might just not like the tenant and make, oh yeah, now this person's out. So it's really hard to say. You know, it depends on your appetite for risk to say, you know, look, if you're like, hey, I might have a chance to get this person evicted. Let me just try. Fine. If you want to spend the money to go do it and file it, just know that, hey, there's a 50-50 chance it might be worth it for you because you're eating it on the front end anyway. So yeah, that's another question. Sorry. So
sorry. Yeah. Alex says, what are the major differences between other states and Illinois when it comes to evictions? I have heard of other states that are able to do them fairly easily. I think Angel kind of hops on top of that. She says, how is Texas evicting?
Yeah, I saw Texas. Yeah, I saw that question pop up as I was asking questions. So again, the state will govern, except if they're not covered persons. So they're probably getting through with not being covered persons. So if there's a CDC covered person, and I don't practice in Texas, and I don't know exactly how they're exactly going about doing it. But the problem we have, and I'm focused on Illinois, is that you've got a very strict city and state that is tenant friendly. In other states, you're still going to have the CDC moratorium. So those tenants maybe not just do not know to bring it to them. Maybe the judges are more lenient. So from that scenario, it could be a case by case basis that there are a lot going through and just people aren't filling out and they're not considered covered persons. But if they're covered persons, then technically under federal law, they should not be evicted, period.
Bibek, I had a question here. So for those of us who haven't had to go through the eviction process quite yet, can you kind of give us just like a high level estimate on how much costs a landlord can potentially accumulate in going through this entire eviction process, so that way they can kind of figure out for themselves maybe the maximum number they would be willing to offer for like a cash for keys scenario?
Oh yeah. Yeah. So usually, the roundabout number I usually give my clients is like, well, one, your holding costs, right? It's one thing. Like, well, what's the reason that how many months are you already behind? How many months do you anticipate to be behind? Because what's the turnaround time, even on evictions, regularly before even COVID-19 happened? It was in Cook County, it was like 3 months, even if you had all your docs in order, like perfectly, and you got the earliest court date, then you got to wait for the sheriff, and then the sheriff's coming out 6 weeks after that. So you're looking at 2 to 3 months. That was beforehand. So you've got that holding cost. So that's 3 months that the tenant's not paying, right? Already on what they had paid. Then you've got, on top of that, your filing fees, estimate about 500. I would say you're estimating about 1,500 in fees, about like if you got attorney's fees, costs, etc. How many tenants you're serving, sheriff fees that can vary. If you have to issue an alias summons, they can vary. So 1,500 is a number that I put out there in terms of cost. Then add on the time, so usually I tell some of my landlords upwards of 2,000, 2,500 might be worth it, I see somebody, I couldn't read all of that, but somebody's like, I'm in a landlord friendly place, and it still stinks. But
The other thing I wanted to clarify here, Bibek, is you had mentioned one of the payment plans that you suggested was like, you have to give the tenant an opportunity to have 2 months for every rent, every 1 month
at a minimum
of rent that they missed. Right. So for instance, if someone, COVID-19 eviction moratorium has been going on for a while now. So like, let's say a tenant has been non-paying for a year. So you're saying that they have to give
technically under the terms of, yes.
Oh, okay.
Yeah. If you read it by the black letter of the law, so that's not an agreement that you're probably going to reach with that tenant who's so far behind. It's probably more applicable. And, when they come up with these ordinances, they whip it out quickly. And then in practice, it's hard. As an attorney, it's really hard for me sometimes to feel like, hey, how does this play out? I'm like, you guys all know that there's the new Cook County suburban RLTO that went into effect, and the language is ambiguous and really has to play out in court sometimes on these. One example I would use to clients is like security deposits. Back in the day, there were people were trying to avoid security deposits and did move-in fees. So everybody did move-in fees. Just got to get by it. Then the courts decided on one case, can't collect more than 50% or it's a security deposit. Now that's not written down anywhere. So how did that come about? That came about through the legal process and the courts making a determination. Everybody found out this court case, and that court case had holding over everybody else. So now all of a sudden everybody's only collecting, nominal move-in fees as it. So that's, it's hard to say how that enforcement, but again, going back to what your question, it's got to be a good faith attempt between the landlord and the tenant. And as long as you can back it up and the courts know that, hey, they tried and they did, you don't have to come to an agreement, period. It says it. You don't have to come to an agreement, but you have to try. I see a lot of questions.
So this question, it says, how have these eviction moratoriums impacted real estate investors in Illinois since many can't collect rents?
Well, here's the thing, the market's so hot right now. I'm doing a lot of transactions and they're still going through. So from that perspective, people are just figuring out ways, like I was telling you guys, like closing costs or taking it on. Even the buyer's like, look, this property is worth it. I'll take on this tenant for the next year. I don't care. The property itself is worth it for me to get. And so you get that situation. But then I've seen ones that are terminated just straight up. Like, I'm not taking this on. The buyer's like, I see the rent roll. This person's so far behind. Or then you've got the escrows. Like I've seen one scenario where a landlord or a seller escrow $10,000 to help cover costs for evictions and possibly another year's worth of non-payment. And for the owner, it was worth it. It was like that credit was worth it because I got my property sold and it's out of sight, out of mind for them. So it's a case-by-case basis on that as to each owner and their proclivity of trying to get that place out and get out from under it.
Can I really quickly continue off of your answer if that's okay? My name is Gabriella and I'm actually, I'm actually a newly branched in investor and I've been looking for my first multi-unit actually for the last year. And I wanted to ask, what are some like general tips like for someone like me, because the market, like you said, now it's pretty hot, interest rates are low, but at the same time, I know that people are just having conversations here that our state is tenant friendly. So many people are trying to branch out and actually, get some properties out of state now just because of that. And I wondered, what are your like general tips? Like, do you think new investors who are just in the beginning stages should wait maybe until August until this gets like cooled down, or some tips if I actually find something now and I just have to be more strict with the tenants that I let in?
Well, I gotta say at this point with the vaccinations going and things that are the way it's going right now, most people have jobs, right? Or they're getting jobs. You're getting better tenants in place, or the existing tenants may have had issues in the past due to COVID-19 and they're legitimate. We can't always look at tenants as being we always have that skewed look from the owner or landlord perspective. Not every tenant's a bad tenant. They may have really fallen on hard times and you have to understand that. But my perspective at this point is, look, the rates are good. This is coming to an end at some point soon. So it's best to, if you can capture it, I don't think it hurts. And Chicago's still a good place. We've got tons of tenants.
Gotcha.
And you can get a single family home that's brick, like it's outside. That's like, you can't, I hear about people in Arizona who get trailer parks that are homes that are like 2 to 3 times more than a brick single family house. In Chicago, they come and they're like, wow, it's so cheap here. Like it is, but it comes with the headaches. It comes with the city of Chicago, quote unquote, tax. You get your housing code issues and things like that. But if you know it and you're going to get hit with it, it's better. But you can make it work, and that's why people come and invest. I'm doing lots of deals because of that.
I think what Jim said, it's very important. The takeaway is to screen for very good tenants and to be very picky. He says here, realize when buying a new asset, it is likely you will have issues with the recent lease ups as they stuff people into units. So as you take ownership of your property, as you replace these bad tenants, replace them with tenants that you screen very thoroughly. I know lots of landlords who have not had any problems, including myself, throughout the entire pandemic, because we had very, very good tenants.
You got to do due diligence. The due diligence is key. You got to make sure you look at those rent rolls, get the Estoppel letters. And if it even means you and the agent go and talk to each and every tenant in the house property, just to get a feel for how they are, that's an option.
And mind you, I've placed 2 tenants during the pandemic and I've not had any issues.
Yeah, no, that's great. No, I've heard, unfortunately, when I'm called, it's usually because of bad reasons. But that means good things are happening. I haven't heard from April.
Thank you for mentioning that, April. I appreciate it.
Gabriella, same thing with us too. We placed 2 tenants during the pandemic and also have not had many issues. So screening's important for sure.
Got it. So you guys think this is just based off of like screening, like you haven't actually had like a good potential tenant that just stopped paying because they just can and they just continued paying, it was okay? And you think that's solely because of screening, because you did your job ahead of time?
There are extenuating circumstances, I'm sure, for some non-paying tenants, but our tenants, we just screen very, very thoroughly.
Got it. Okay. Thank you, guys.
All right, Bibek. Well, first off, I know that you had said 2:45, so thank you so much for staying a little bit over, but don't want to keep you any longer.
That's okay.
Yes.
Thank you, Bibek.
Thank you, Bibek.
No, thank you.
With us.
If
thank you.
Feel free to reach out with some questions. That's fine. Thank you. Thanks,
Absolutely.
everybody. Enjoy the Memorial Day weekend.
Enjoy.
Thanks,
Bye-bye.
guys.
Thank you.
everybody.
Yeah.
Thank you.
Talk
All
to you
right,
guys
so I'm going to
later.
go ahead and stop the recording now. We'll go ahead and bring you guys into break.